Hi, my name is Olga D, and today we're going to speak about legal and ethical issues for healthcare professionals. This is a class HCL 420 for National Louis University, and we're going to talk about 5 things new managers need to know about healthcare ethics and laws.
As managers grow into their careers, they hear a lot of voices from physicians, staff, patients, other people around. And as they go, they may doubt the things that they know that are right or wrong. Healthcare ethics deals with the section of healthcare that truly addresses such issues. Ethics and laws are two different things, so we're going to give a definition for ethics first. Ethics is defined as the branch of philosophy that seeks to understand the nature, purposes, justification, and founding principles of moral rules and the systems they comprise. So, on the other hand, laws are defined as enforced regulations that govern the relationship between private individuals and organizations and between both these parties and the government. Someone once said that the laws society has defines that specific society, so the government represents the people. Thus, the moral values these people hold represent them. The ethics is based on pillars of moral strengths such as courage, wisdom, temperance, commitment, compassion, consciousness, discernment, fairness, fidelity, freedom, honesty, integrity, kindness, respect, hopefulness, and tolerance. These are values that comprise someone's character, someone's view for life, and the ethical conduct that person may perform. For example, Immanuel Kant said that in law a man is guilty when he violates the rights of others. In ethics, he is guilty if he only thinks of doing it. Therefore, we must ask, what are really those 5 things new managers need to know? Now that we know the definition of ethics and laws, we understand that the tools are out there and it's so much easier to navigate through the issue that patients experience. Therefore, we're going to look into informed consent, patient abandonment issues, physician credentialing process, fraud, and end of life dilemmas. Patient consents must list potential risks, benefits, and alternatives of a medical procedure. These could be oral or written, but the bottom line is that the legal terminology should be explained so that patient understands everything. Above all, healthcare professionals, physicians, need to determine patients' capacity of decision making. Otherwise, a consent will never be considered as valid. Risk management experts even question how informed are the patients indeed when they sign off a document under the pressure of an immediate intervention, a surgery, or something that is like life threatening. There are several tips that managers should consider when creating informed consents for patients or when allowing for the consents to take effect in a practice. They could contract an outside vendor or company to design these consents. They could also work with the risk management department, involve marketing agents, marketing department of an organization, obtain legal advice from the attorney's office or any other legal department, and also consult the ethics committee. This will help the informed consent process to be truly meaningful and waive huge amount of liability away. An example that I have is Carol Weimer's case, and this patient sustained emotional trauma after experiencing anesthesia awareness. While in surgery, the patient could hear doctor's conversation in the background, music playing, and a lot of other things. She did not feel any physical pain, but the patient did suffer an emotional injury. The second thing we're going to discuss tonight is patient abandonment. In order for abandonment case to be filed, four things need to be present. The duty between the patient and the professional should exist. The breach of that duty will also follow. Causation and harm must be present. Let's look into a typical scenario. Department is short on staff and the nurse has to cover two units, and she runs back and forward. At a point, she stops visiting the second room because she realizes that the other patient is more in need of attention. Extended shifts should not be more than 72 hours worked a month. The 72 hours and overtime will be the cap hours an employee could work. Also, insurance issues may lead to patient abandonment cases. For instance, patient is with PPO insurance and then he moves to an HMO and the Dr. X is not covered under the new plan. The doctor is responsible of transferring the patient to the new primary care physician, so abandonment does not occur. A third thing managers should know about is physician credentialing. Credentialing requires a lot of steps, and a physician does need to follow these steps because the liability will diminish if all the procedures are followed correctly. So the credentialing process should be done according to organization's bylaws. Peer-to-peer reviews, letters of recommendation, checks of the state license, and board-approved certificates should be also presented. Verifying any sorts of information, background checks is also much needed. There are a couple of sources that hospitals and credentialing departments may use to assist with the credentialing process. But it is very important to understand that proper credentialing, approval of those procedures that a physician plans to perform in the future, will save a lot of time for possible court cases. Maybe it sounds bizarre, but proper credentialing will improve the quality and safety of an organization, and patient rights will be fulfilled correctly. Case that I wrote about speaks about fraudulent misinterpretation of a dermatologist who wanted to perform a plastic surgery. The case ruled out a credentialing issue, a patient informed consent, and the injuries of that procedure were also presented at the courthouse. Questionable physician's behavior is always a suspicion for fraud. And fortunately, the Affordable Care Act under Title VI addresses this issues that fraud has always been dealing with. The transparency and integrity of the programs that each state deals with will help screen out and identify fraud more quickly. So fraud will be the fourth thing a manager should know about. Any billing suspicions, any underperformed or overcharged procedures are considered as fraud. Selling medication from a patient's rules, falsification of records, performing procedures that don't belong to physician's scope of practice are also considered fraudulent. Ultimately, we're going to discuss the end-of-life dilemmas a manager should totally be informed of. Documents such as living will, durable power of attorneys need to be filed under patient's chart, and the staff needs to be trained how to correctly obtain, witness, and process such documents. There are several laws that assist with patient end-of-life dilemmas, such as the Self-Determination Act, the Act to Refuse Care. Even the assisted suicide issue has been ruled under the Oregon's Death of Dignity Act. The euthanasia law is banned in the United States. All in all, a manager should have general knowledge about end-of-life dilemmas, dilemmas that pertain to futility of treatment, withdrawal of treatment, or do not resuscitate orders. Bottom line, an ethics committee can always be consulted. The care team also has to be involved when decisions like that are being done. If a solution will not be ruled out at the hospital level, the case will definitely be taken to court, and then the legal part of the case will follow. In conclusion, a brand new manager should be prepared to consult other departments of the hospital, such as the legal, marketing, risk management, human resources department. Other departments then can help with decision making at the leadership level. So, the 5 things a brand new promoted manager should remember are absolutely about patient-informed consent, patient abandonment liability, physician credentialing process, fraud effects, end-of-life dilemmas. And if by any chance a manager forgets the golden rule of medicine, which states do not harm under any circumstances, a manager role will definitely always affect patients' care. Remember that conflicts can be resolved ethically or legally, and that not everything that is legal is ethical for everybody. Bottom line is that patients need to be treated as individuals with great respect for their personal values and judgment. Thank you for listening, and I hope that today's information was absolutely useful.